Mr. Levick began teaching American government at Pierce College, and he discovered that teaching was more enjoyable than he had imagined. The following year, he began teaching a current events class for the Pierce College Encore program for older adults, a weekly program of non-credit classes. Today, in addition to his American government classes, he teaches 4 current event classes each week during the regular school year, plus classes in summer and winter sessions. Each summer, he teaches a non-credit seminar covering the recent interesting decisions of the U.S. Supreme Court, sometimes just weeks or days just after the court renders its decision. We welcome Mark back with us today during a very interesting time for SCOTUS in his presentation, The U.S. Supreme Court, Not Elected Legislators or Impartial Arbiters. Mark, welcome.
Thank you. How's that? Everyone can hear me? Wonderful. I'm glad to be here today. When Joel asked me what dates I was available, he listed a bunch of dates, and I said, no, I teach a Monday morning class now, and that's not going to work. I said, how about April Fool's Day? He said, perfect. He'd find someone to move so that I could have this spot. Thank you again for being here. I want to talk today about some of the more interesting or controversial cases. I'm sure you're familiar with at least some of them, and I want to give a little bit of commentary about them. In addition to that, I want to address one item that I talked about last time. When I was here last time, it was December of 22, and after President Biden had won the presidency in November of 20, many of the progressives, many of the liberals said, we need to expand the Supreme Court. That is number one. President Trump had, thanks to Senator McConnell of Kentucky, he'd won an extra Supreme Court nomination that many people think rightly belonged to President Obama after Justice Scalia passed away. And so they held that open for almost a year. And then Justice Gorsuch was named, and many Democrats were rightly angry that President Obama had been deprived of the chance to name someone to the court. And so President Biden, being an institutionalist, certainly one of the establishment, he appointed a commission. He named many noted academics and judges and people to examine the different ways that we could change the makeup of the Supreme Court. There were committees that looked at term limits. There were committees that looked at expanding the court to, say, 13. And the conclusion, I examined a lot of their materials, and I concluded that that doesn't really have a chance. Politically, it might be dangerous because you know what happens the next time the other side prevails. We get into an arms race in the Supreme Court. At some point will be 57 judges because you have to keep making it bigger, much bigger. And I think it's a geometric progression as you attempt to undo what the previous government put in place. Nevertheless, I saw something the other day that talked about how aged some of the justices are getting. None of them are in their 90s or upper 80s, but they're getting up there. And so in the next several months, I'm sure there'll be those whispers of maybe it's time for some of the, I think one of the President Obama nominees is nearing 70. Maybe it's time to lean on her and say, you've been a justice now since the Obama years. Maybe it's time you step aside. Of course, many Supreme Court justices, they push back very strongly. Ruth Bader Ginsburg was Exhibit A. She could have retired in 2014 before the election, and President Obama would have been able to name somebody because the Democratic Party still controlled the Senate. But what happens with people, and I'm sure I'll do this too, at some point somebody's going to say, you know, Levick, maybe you could think about retiring and joining the Encore program or attending a Hazak program. And I'll say, oh, no. I'm the only person who could do this. I'm irreplaceable. Everyone, I'm sure, at some point thinks that. It's going to be difficult for me, but eventually I hope that they don't have to take away my keys. I hope I turn them over voluntarily. But I'm sure we'll hear more about that. And on that note, I just saw something last week that progressives in Congress have reintroduced a bill to, yes, expand the Supreme Court to 13. The intention is to minimize the influence of politics on the court. But as many of you recognize, that would, of course, be an expression of politics, making the court 13, giving President Biden some of those additional. Now, in 2021 or 22, the idea was President Biden might be given 1 or 2 appointments each year. He wouldn't get to name 4 or 7 or 6 right away. But now President Biden, in his first term, only has a few more months. But on a political level, well, you have to control the House and the Senate to pass a law. So unless a couple more Republicans depart, and a bunch of them have quit lately, and it seems to be strategic quitting because they seem to be leaving in a way that makes it harder for other Republicans to have special elections that would give them some advantage. So one of the representatives is saying, we need to kick that guy out now so that he won't disadvantage us. But here they are still talking about expanding it. It was sponsored by several of the typical Democratic representatives. But I can just push that aside and say, not a chance. That's never going to happen. Unless one of the parties gets an overwhelming number of senators, or somebody blows things up and says, let's abolish the filibuster. And that carries its own risks. I don't give Mitch McConnell a ton of credit, but he didn't blow up the filibuster other than for Supreme Court justices. And that preserved the Affordable Care Act, for instance. When John McCain walked in that one night while he was terminal with brain cancer and voted to not repeal and replace the Affordable Care Act, that was a lesson that maybe those institutionalists are onto something. Well, let me get to my notes here, because I've got a few different topics to discuss. After the expansion, then we get to the, if you're convicted in a district court in a state, Colorado, for instance, are you eligible to run for another term as president? Well, my Constitution, I've got a little pocket one here I give to all my political science students. My Constitution in the 14th Amendment seems pretty clear. Section 3 of the 14th Amendment discusses this. And in quite a bit of language, it says, no person shall be a senator or a representative or an elector of the president or vice president or hold any office if they've previously taken an oath as a federal officer and then engaged in insurrection or rebellion. Now, we all know why that was originally written in 1866 and ratified in 1868. That was to prevent popular insurrectionist Confederate leaders from getting elected. And in some cases, states may have prevented insurrectionists from being elected in their states. It also contains some language, though, at the end, and the last part that says, but Congress has the power to enforce this by appropriate legislation. They put that in a lot of amendments. That's fairly standard language. And in Section 3, it says, but Congress may, by a vote of 2/3 of each house, remove that disability, allow someone who engaged in insurrection. And throughout the 1870s, they did just that. They passed some bills in Congress that allowed some people who'd engaged in insurrection to be elected to the House or to the Senate. And at the time, no one thought, I'm sure, they'd ever be faced with somebody 150 years later who would engage in acts that, at least that Colorado District Court said, after a 5-day hearing, they held a hearing, they had evidence, they had witnesses, and the court said, well, he engaged in insurrection, and the district court said, but he can't be blocked by a state court. And then the Colorado Supreme Court got the appeal, and they said, we agree with the part where he engaged in insurrection, and we disagree with the district court. He can be blocked from being on a primary ballot. Now, the former president said this can't happen, and he has lots of lawyers. The one thing he has is more lawyers at his beck and call than most people. And they appealed. And they appealed to the United States Supreme Court. And that was an example where the U.S. Supreme Court, they worked as though there was a fire lit beneath them. They responded very quickly. They didn't say, oh, let's put this off, for weeks and weeks and weeks or months. They held hearings right away. They held arguments, and then they released their opinion fairly quickly. And in a unanimous opinion, and it's not really unanimous, it was a 5-4 opinion, where all 9 of them agreed on the result, that a state can't bar someone under the 14th Amendment from being a nominee on the primary ballot. But 4 of them disagreed with all of the extra language. Now, here is an example, I think, of the Supreme Court majority, the 5 conservatives other than Amy Coney Barrett. Amy Coney Barrett is the 6th, but she concurred in the result, but she criticized all that extra language that the majority, the 5 others, listed. And they put forth a ruling that they didn't need to decide. Instead of just saying the state cannot prevent a person from running for president under the 14th Amendment. That's all they had to say. They could have listed the reason why they decided that, but they didn't have to go any further. They went further and they said only Congress can prevent someone from running. And Amy Coney Barrett, to her credit, said they didn't need to say that, and that forecloses any other method for preventing an insurrectionist in the future from being held off the ballot. And then the other 3, the 3 reliable, President Obama and President Biden nominees, Justice Sotomayor, Justice Elena Kagan, and Justice Ketanji Brown Jackson, they echoed much more forcefully Amy Coney Barrett's view. You didn't have to make a rule that so strictly limits the ability to keep somebody off the ballot if they're an insurrectionist. Providing that only Congress can do that, I don't think it takes much imagination to conclude that it's going to be very unlikely that Congress will ever agree on something like that. I can't picture that Congress would ever agree. In an age when Congress can't agree to help Ukraine or provide funding that President Biden asked for months and months and months ago for Israel and Taiwan, in a Congress that can't do something so ordinarily establishment, I can't imagine Congress will ever touch something that's so politically charged. You want to keep my person off the ballot? No, I'm unwilling to vote for the things that are, ordinary, like keeping the government open on a normal schedule or helping our allies. I don't see Congress ever deciding by a majority vote that someone is an insurrectionist. Really good arguments by the commentators about this case. One easy one is, so the Supreme Court has told us it takes congressional action in order to keep somebody off the ballot. But the amendment itself says you can be forgiven by a 2/3 majority, a supermajority of the Congress, to forgive somebody who's an insurrectionist. So a majority either provides or doesn't provide that someone is an insurrectionist and is ineligible. But at the same time, then it takes 2/3 to decide that it's okay and forgive that? Well, that, of course, that decision was expected. I didn't hold any hope that they would rule that the former president was ineligible. So many people have said, including former Vice President Mike Pence, that the voters should decide. And my initial reaction to that was, well, Mr. Vice President, the voters did decide back in November of 20, and we saw the reaction. He's under indictment for insurrection. Well, not insurrection, for the events that led to the violence on January 6th. And it's, I think, Mitch McConnell who said on TV right after the impeachment, after he was out of office, oh, don't worry, the criminal justice system can take care of this. And, well, as we'll talk about in a minute, there are doubts that the criminal justice system is going to be able to vindicate the rights of society by either deciding guilty or not guilty prior to November the 5th. November the 5th is speeding along very quickly. This is already April the 1st, so I don't hold any hope that we will get to learn in a trial whether there's guilt or not guilty. And then there's another related case, and that's the former president's claim for absolute and total immunity from criminal prosecution. That one is, it's a big, I think the 11th Circuit, and that was a judge that had been nominated by President George H.W. Bush. That was a long time ago. He was president from 1989 to early 1993. That's an example of the long reach that a president can have. They name somebody to a court, and they're there for a long time. Justice Clarence Thomas was named by President Bush number 41 as well. And I think he's only about 70 or so. And that's been a long, long time ago. Republicans learned, and I think Democrats are taking the lead on that as well. Don't name somebody like me, name somebody who is still raising their little children, like Amy Coney Barrett. Because if you're still raising little children, the president will be out of office for decades, maybe before that justice ceases. But in the immunity case, it was the George H.W. Bush justice, or judge on the Court of Appeals, who asked, so let me get this straight. If the president were to order SEAL Team 6 to assassinate a political rival, are you saying the president has immunity from that? And the lawyer for the former president said, well, if they were impeached and removed by the Senate, then you could hold a criminal trial. But again, impeachment takes 2/3 of the Senate. And as we saw in both impeachments, they pretty much came down on the political ledger the way we expected. On the second impeachment held after he was out of office, and that was mostly to prevent him from running again. That was the goal, at least to show, well, we're not happy with this, and we have a remedy. We're going to remove you, and you can't run for office ever again. Well, that one failed, but it did get 10? Was it 7? I think it was 7 Republican senators, including Mitt Romney and several others. And so we did see that although it failed because it was 57 votes to convict instead of 67, the 2/3 the Constitution requires, we did see that egregious conduct will occasionally get the Liz Cheney, Adam Kinzinger types to cross over and say, well, this crosses a line. This is not a political matter. This is democracy at stake. Well, the Court of Appeals unanimous decision. One of those judges, as I said, was a George H.W. Bush appointee. The other 2, I think, were President Biden appointees. But it was a unanimous decision. And so you have a long-standing conservative judge, and then you have 2 that probably aren't as conservative. But when 3 judges come up with a unanimous opinion and nobody dissents, I put some faith in that as not being a political decision, but being in that category of protecting the legitimacy of our democracy type of decision. But nevertheless, the president, I think it was arguments in January, the decision was in February and late February. And then he immediately appealed to the Supreme Court, and the Supreme Court said, no hurry on this one. unlike the decision of Colorado. This may be another example where they're putting their thumb on the scale. In the case of the 14th Amendment, perhaps that was several justices acting as legislators and not simply looking at the law and making a reasoned decision. After all, there were a couple of law professor types, members of the Federalist Society, who wrote a big, convincing argument that they published a year ago that said the former president is guilty of insurrection and is not eligible. And I read that a couple of times. It was 100+ pages, but they were convincing, and they were Republican Federalist Society judges and law professors. So I took some faith that that wasn't a politically motivated conclusion. That was one based on law and reason, the things we hope they do. But when he appealed to the Supreme Court, they said, well, we're going to hold arguments April 22nd, a long time after the appeal. In fact, that's the end of their oral argument session. Of all the cases they'll decide this year, that's when they'll hold their final oral arguments. And as we know, that means the decision should be expected by, June 29th or June 30, the last day, when they release the big decisions. Think about the Dobbs decision that overturned Roe v. Wade, or the decision last year in the Harvard and University of North Carolina cases that undid affirmative action in college admissions. Those cases come out at the end of the term because they're the big cases. Well, if the decision comes out on June 30, then I don't think there'll be a trial in Washington, D.C., because that trial, this is the one on the overturning the election. There are 4 counts. I don't think that trial could possibly happen before the election. There's so many pre-trial things that have to happen, and between now and June 30, that judge is going to have other things come up, and the calendar will get full, and the lawyers will say, well, Your Honor, we need 3 or 4 weeks, or maybe 6 weeks to conduct this trial, and the judge is going to look at their calendar and go, when do I have that much time open? And so I suspect that trial won't happen. In effect, I'm going to blame the Supreme Court justices, no matter how they rule. Even if they rule, the president, of course, has no absolute immunity. But, they could have ruled on that one almost right away. There's nothing in the Constitution about this, but by custom, by tradition, the Supreme Court only takes an appeal if 4 of them agree to it. If 3 of them say, we should take this appeal, by custom, the justices say, no, it takes 4 of us to hear the appeal. Otherwise, the petition is dismissed. And you don't get to have your appeal heard if only 3 of the 9 agree. But if 4 of the 9 agree, then we'll hold all arguments, and then we'll decide the case on our either hurry-up schedule, like they did the 14th Amendment one, or on the routine, regular schedule. That means on June 30, the next day, if that's a weekday, try as they might, there won't be enough time to hold a trial. It just won't happen. And the former president, of course, has said or implied that if things don't get resolved before the election, then when he takes office, assuming he prevails, then he can, and here's Levick's view, he can commit obstruction of justice because he'll name an attorney general, that Jeffrey Clark fellow. He was the one whose colleagues derided him as, you're an environmental lawyer. Go back to your cubicle and we'll call you if there's an oil spill. He was the young man, the very ambitious man who wanted to be the acting attorney general right at the end of around the time of the insurrection. He and some others were lobbying to have him made the acting attorney general because all the other establishment people had said, no, you do this and we'll all quit. And it would be a Saturday night massacre. We didn't want to see that. And so an attorney general gets named on January the 20th, late in the afternoon, say next year, if the former president becomes the trivia answer to who are the people who served a term, were defeated, and then served another term. Grover Cleveland is the only one now. But if he joins that club, Of course, he would order his attorney general to dismiss any pending federal actions against him, or they would use their ordinary rule, their custom. They put out a memo decades ago at the Justice Department that says acting presidents, sitting presidents, won't be prosecuted while they're president. And so the criminal prosecution has always been deferred until after the president is out of office. And they decided that, I think, at least around the time of Nixon, if not before. And so it would be deferred for up to 4 years if that happens. But amazing how they were able to speed through the 14th Amendment case so quickly, and yet they couldn't simply adopt the view of the unanimous Court of Appeals and say, no, we're not going to take this case. It was a really great opinion, I thought. It was well written with argument, not shallow emotional reasons like I would write, but actual legal arguments, things I could respect. And so I predict that they will come back and say, oh, the president doesn't have complete criminal immunity, but we've delayed things just long enough. A lot of writers, some of whom I read and respect everything they write, have said this was certainly an assist. If you're a basketball aficionado, put this in the assist category, because this was several of the Republicans on the Supreme Court giving a big assist that will prevent a criminal prosecution, even though I think a majority of people have said this prosecution has some merit, or at least parts of the prosecution do. And then there's another case, because we thought, well, I thought at least, that after the Dobbs decision, which overturned 49 years of precedent, that women had a constitutional right to determine whether they had a baby or not. After that decision, remember the common view was, well, this is just going to turn it back to the states, and states can decide. States can have no abortions at all, or states can have a 6-week limit, or they can have a 15-week limit, or they can do what they want to do. And I've been telling students even before I was teaching in the Encore program back in 2010, my view has been President Reagan's promise will eventually happen. So you need to plan accordingly. I remember in 1980 when he said, elect me president, and I'll get rid of that 7-year-old precedent, the abomination of Roe v. Wade. Over that 7 years, the people in the Republican Party had gravitated toward the pro-life or pro-forced birth, depending on your point of view, position. And people in the Democratic Party spent those 7 years gravitating toward the pro-choice, women can decide what they want to do side. Initially in '73, it wasn't a cut and dried partisan issue. There were people in both parties on both sides of that. But by 1980, candidate Ronald Reagan was saying, name me president, make me president, and I'll name enough judges to undo this. And I think back, 7 years ago. What was 7 years ago? President Trump's inauguration. He was just learning how to be president 7 years ago. That wasn't that long ago. It was still fresh in our minds in 1980. Well, President Reagan tried. He named several Supreme Court justices, but in 1992, the Casey decision affirmed most of Roe v. Wade and added some more conditions and structure. And then I thought, President Reagan's unsuccessful. And President Bush then in 2001 attempted. He named John Roberts and he named Alito. He got partway there, but it was unsuccessful. And then President Trump, with that assist that I mentioned from Mitch McConnell, President Trump got 3 nominations in 4 years. That's much more than the typical. Usually it's 1 or 2 Supreme Court justices for every 4 years a president serves. But then he also had that assist from, Justice Kennedy. And remember, Kennedy was the replacement for Bork. When Bork was borked, when he was defeated in the Senate, then President Reagan said, how about Anthony Kennedy? And they were all tired, and they said, okay, and I don't remember much debate at all about Anthony Kennedy. But he retired at a fortuitous time, I think in 2018, which gave President Trump the chance to name Brett Kavanaugh, a former White House lawyer for George W. Bush. And then, as I mentioned before, poor Justice Ginsburg's gamble didn't pay off. You can't live forever, and if you hope to outlive, politics, it doesn't always happen. And so President Trump ends up with 3 added to the other 3 Republicans, and we're in a 6-3 vote. So Justice Kavanaugh, in this mifepristone case, this was the case where we thought the abortion, I thought prior to this that the abortion case was done. But unfortunately, I was wrong. One commentator says the current attack on abortion pills will fail, but the next one will be so much worse. There's a brand new changed rule. Just the other day, the Commission on the Federal Courts, I think that John Roberts, the Chief Justice, appoints, they came up with a change to the rule that allows litigants to file in the court they want to file in and allow them to pick their judge. All over the United States, there are 92 or so federal court districts. Every state has at least one, and of course some states have multiples. But in every one of those districts, they either have a random assignment or you file in whatever part of the state when you want to go judge shopping. And in Amarillo, Texas, there's a well-known judge who President Trump named, who's been telling everybody, sort of like Bork did a long time ago. Bork's sin was that he'd published too many books and law review articles saying, well, I'm going to change this if I ever get named to the court, and I'll change this and this and this and this. And ever since, all of the nominees have kept their cards very close, and they've said, well, I can't really talk about that, Senator. I'd have to wait until the case comes before me. And so the people who are on the Supreme Court track, they've not told everybody what their views are. But this judge, Judge Kaczmarek, he's the district judge in Amarillo. Amarillo, in the district in Texas in which Amarillo resides, they have you can file wherever you want, and your case will be heard in that part of the state. Texas has, I think, 3 federal districts, and so Judge Kaczmarek's the only one in Amarillo. And under the rules up until recently, that meant if you filed your lawsuit in Amarillo, then you were in front of Judge Kaczmarek. So those who are not content to simply allow Texas to do what it wants with abortion and California to do what it wants, or Kansas and several other states where even in Republican states, when it's been put to the voters, women have chosen, and men have voted as well, to preserve the right to choose, even in Republican states. But those who want to control more, well, they went to the 1873 Comstock Act. I had to look this up. Back in 1873, Congress passed a law that said it was a federal crime to send anything obscene or immoral or having to do with birth control or abortion or anything through the U.S. mail. And I look at laws like that, have a moralistic origin, and I say, well, that can't possibly be a good law now. But these litigants have said, oh, no, that's has never been repealed. And some of the judges at the oral argument said, no, this is good law. It's easy to find. And so the company that makes this mifepristone, which I've heard is now responsible for 2/3 or almost 2/3 of the abortions in the United States. And over 5 million women have taken this drug in this country. And it's approved in many other countries. It's been available since 2000. And I think it was 2016 that the FDA made some relaxations, so you didn't have to go to a special doctor to get it approved and have it prescribed. You didn't have to jump through as many hoops. And then I think in 2021, they further relaxed it, probably anticipating that Dobbs was coming down the line. And so now it's available by mail. The thing about the mail is the state of Texas and the state of Florida can't open your mail. I think that's a good thing. The United States can open your mail if they get the proper warrant, but the states can't interfere with the federal mail. When someone mails you something, your state can't say, let's see if they're getting something that's approved and unwrap your package. Wait a minute, we don't let you buy this in this state. Now, there are companies that won't sell you, for instance, rat poison to California because California has banned certain types of rat poison, which I think is a good idea. And so Amazon, for instance, won't ship certain things to certain states, but that's not because the governor in certain states is saying, check and see what Levick's getting in his UPS package or his mail today. But since they can't do that, they've said, well, we need to prevent anybody in the country from getting mifepristone. So the doctors, their witnesses that they relied on said, well, we're worried that somebody might take this drug and then force us to take care of them in case something goes wrong. And since we're anti-abortion, we don't want anybody to get this drug because it might, maybe, cause us to have to treat that woman in the future. The Judge Kaczmarek, he bought it hook, line, and sinker. The critics of that decision point to all of the we shouldn't call them studies because they're not actually studies. One of the commentators says, and in fact, I think it was one of the judges pointed out that the people attempting to ban mifepristone, they relied on one study that was a bunch of anonymous posts on a blog. That's not medical evidence. That's sort of like that vaccine reporting system where if somebody gets a COVID-19 shot and then they think it's caused them harm, there's an anonymous place the federal government runs where you can type in all your symptoms, and you know, conservatives and those opposed to getting COVID-19 shots that will keep you alive, they've said, well, on this vaccine reporting system, there's lots and lots of evidence that it's dangerous. Look at all the self-reported problems. Well, it's an anonymous system and anybody can just type it in. I'd be willing to bet, not a lot of money, but I'd bet some money that there are people in parts of the country who are opposed to the COVID-19 vaccine, and they may have made it sort of a cottage industry to, you know, put a whole lot of those reports into the system. Because most people probably aren't that motivated, but if you find a lot of them, put it through the plagiarism checker, the online tools that us professors have, and you might find similarities. Maybe there's a form people are filling out. The other study was a study that was conducted by, I think, someone who's not actually a doctor. They have a master's in some subject, but they're not a physician. And that was the evidence that Judge Kaczmarek said, well, this is, we're going to ban this. The FDA exceeded its approval, and the Comstock Act was violated when these companies mail these drugs. Oh, boy. So that case is, it's hard for me to keep track of what we call the posture of that case because right away, a panel of the Fifth Circuit Court of Appeals, and that's a very conservative circuit, between President Trump and President Bush, I think they've nominated 70% or more of those judges. So the odds are at least 2 of the 3 randomly selected at the Court of Appeals will be on the conservative side. There just aren't very many Democratic nominees to go around. And they put a pause on enforcing that decision pending the appeal, and now it's up at the Supreme Court. They haven't let the appeal play out at the Court of Appeals, but the Supreme Court heard arguments in that case. Oh, I want to mention one more thing. The change that the commission put together will now prevent, probably, litigants from choosing their judge. So if you want to file a case in that district in Texas, which is Amarillo and a few other places, then it'll be randomly assigned to the judges in that district. The former president filed a couple of things in, Fort Pierce, Florida. I'm a Floridian, but I couldn't find Fort Pierce if I had to. It's a little outpost 40 or 50 miles from West Palm Beach. And there's one judge in the Fort Pierce courthouse. and that's Judge Aileen Cannon. She was one of the last judicial appointments of the former president in the summer of 2020. And she hasn't done a lot of criminal trials, of course. And right away, after the search of the former president's place in Mar-a-Lago, his lawyers filed a motion to prevent the government from investigating the documents, many of them marked classified or top secret or various, classifications by the spy agencies and the Department of Defense and whomever. She put a pause on the investigation. The government had the documents, but she ordered the government not to look at them and develop any criminal charges. And the Court of Appeals in the 11th Circuit smacked her down unanimously. And it wasn't a gentle, oh, you made a mistake, Judge. It was a beatdown. And then she did something else, it escapes me, and they had to do it again. And they were unanimous opinions. And they were written by predominantly Republican appointees, Trump appointees, Bush appointees, on the 11th Circuit Court of Appeals. And so that's the case where the president filed those in the Fort Pierce courthouse. But it wasn't a foregone conclusion that she would get those cases, because the Palm Beach district of the federal court system does have a random assignment, but there aren't very many names on the wheel. And so there are several judges, but there's a couple that don't do many cases, and there's one judge that doesn't do civil cases, and one judge that doesn't do criminal cases. And so there weren't very many names on the wheel, but they spun the wheel, and Judge Cannon came up. And then when Jack Smith filed his criminal charges for taking and hiding and not cooperating with turning over all those classified documents, I think it's over 100 of them, they filed the indictment, and then they spun the wheel, and what do you know? She got the case. And so a lot of people were misinformed that somehow that was a foregone conclusion, but no, that was just the luck of the draw. But there weren't very many names on the wheel, and so it wasn't long odds. But she ended up getting that case as well. From now on, I think these new rules will prevent that kind of judge shopping. In other districts, like in the one in Amarillo, you file in Amarillo, you were going to get Judge Kaczmarek unless he had some disability, unless he was foreclosed because of a conflict of interest or something else. He was going to get every lawsuit filed in the Amarillo courthouse. Going forward, I believe these new rules will mean you only get Judge Kaczmarek or Judge Cannon if the random assignment causes that to happen. But as we've seen, Judge Cannon just keeps coming up. And I'm not sure if you'd agree with me, but if I were a trial judge and I'd been appointed by somebody, and then that somebody was the subject of a criminal charge, I might think it wise to recuse myself. Surprising that the rules that apply to judges have no provision that say the person who named you to be a judge, you shouldn't hear any criminal charges against them. I haven't looked, but in some states, governors get to appoint judges. And I wonder if any of the states permit a judge that the governor named to hear criminal charges against the governor. Now, they probably wouldn't be for insurrection or the taking and hiding of classified documents. That kind of case would be the governor was accused of drunk driving, and was in the courthouse, and then, well, hi, Your Honor. Hi, Governor. I would assume that most states would say, no, another judge should hear that case. But apparently in the federal system, I had no idea. I've not been a litigator. I don't go to court. When I was a lawyer, I was in the fancy high-rise office, in the big office, in the conference room. That's where I did most of my work. So I wasn't too familiar with criminal procedure. But in the federal system, apparently there's no disability. And so the judge that named the person who's in front of them on a criminal charge, I guess that's okay. But I would say, no, that's probably the first. What other disability might there be? Oh, if Judge Cannon's father, for instance, committed a crime and was in front of Judge Cannon, would it be appropriate for a judge to rule on that? I would think not. But I'm not going to take a position one way or the other because I just can't be sure. And then there are a couple of other cases. Because the former president, according to Twitter, X now, Elon Musk, he has to rename everything X, SpaceX, X.com. That was what PayPal was going to be. That's why his partners pushed him out of PayPal, because he wanted to change the name of PayPal 20 years ago to X. But X, the Twitter, and Facebook, and YouTube, after January 6th, those social media companies didn't just put warning labels and context labels on the former president's postings on social media. They finally banned him on January 7 or so, right after the incitement of violence. And the reason they gave was, we're going to ban this guy. He's going to be out of office soon because we don't want him to incite any more violence. We don't want to be a part of that. And Republicans in Texas and Florida and a few other states said, you're preventing conservative speech. You're censoring the President of the United States. You have it in for conservatives. My initial reaction was, no, you can still post all sorts of Republican ideas, but insurrection and violence, that's where they draw the line. But Republicans in both Texas and Florida, in their state legislatures, and Republicans control those states almost as much as Democrats control this state. I think more than 3/4 of our state assembly and our state senate are Democratic legislators now in California. It's almost that big in Texas and Florida. And so they passed a law in both states that prevents the censorship of conservative ideas by the Silicon Valley elites. I don't think it was Silicon Valley wanting to censor. Oh, and as a threshold matter, when you hear the word censor, does that call to mind a private company that tries to make profits that says, you can't say that in our store, you can't say that on our website? That's not what I think of when I hear the word censor. I think of government saying, you can't say this, the state imposing censorship. I don't think of it as a private company's decision, but I think of it as, the state is doing that. So there are state laws in both Texas and Florida that will be in front of the Supreme Court. Later on, I think arguments are going to be held sometime this month where they will then rule on whether those are permissible or whether those are, just faulty. The arguments of one of those states is social media companies are just like common carriers, and you can't delete or block or prevent anything. You have to take everything as it comes. Well, I would look to the turmoil on our campuses all over the country. Since October 7, we've seen so many universities who didn't say anything and everybody's mad at them, or they did say something and everybody's mad at them. All of the university presidents and chancellors and board of trustees, because there are people who thought the resistance was their viewpoint, universities have seen presidents ousted, donors have said we're not going to contribute, and so we've seen a real struggle at those universities to contain what appear to me to be gross anti-Semitic protests and actions. And I've heard that anti-Semitic conduct at these campuses has gone up multiple, just like it has throughout society at large. And so with states like Texas and Florida saying we need to make sure that conservative ideas are upheld, and so Facebook and YouTube and X, they can't moderate any content at all. I can only imagine how ugly that content's going to be. We have a preview, though. Elon Musk, when he bought Twitter for $44 billion. All he had to do was start his own, call it Truth something or other, and I think the market cap today is $7 or $8 billion for that company the former president started. But Musk bought Twitter, and right away, he allowed back all of the people that Twitter had spent years figuring out who they were and banning them to the best of their ability. And ever since November of 22, we've seen Twitter host an awful lot of real hateful speech, awful content. And so I'm wondering if the Republicans in Texas and Florida have thought this through. Because if they win and it's a common carrier, think of all the hate that they're going to object to. Now, it's not a partisan thing that is angry about the university's delay or saying the right thing or the wrong thing in the months after October 7. But I will note that I see a fair amount of anger on the right when it comes to the Harvard president, the MIT president, the Pennsylvania president, some of those that they were successful in unseating. And it's still something that is a constant item of discussion on Fox News or the New York Post or the Wall Street Journal. The failure of these leftist universities to, do the right thing. Well, I wonder if they realize just how awful things are going to get everywhere if no private company can moderate the content. Restaurants can still say no shirt, no shoes, no service, but apparently social media companies won't be able to. I would argue that the common carriers are the internet providers. When you get, some of you may have internet through Spectrum if you have cable. Some of you may have AT&T's DSL. I'm one of those. I would argue that those companies can't moderate what I look at on the internet. But if I go onto an online bulletin board and I say, this is my way of thinking, I would hope those companies like YouTube could say, oh, no, you can't post that. And so being that they're profit-making companies, I would think they would want to be able to pick and choose. And all of them are doing, I think, a decent job, except maybe Elon Musk's company, because he's made a conscious choice to invite back racists and anti-Semites in fairly large quantities. And then there's another case that raises this. Oh, before I get to that, I want to mention real quick. I saw the other day that Ben Stern, he was the Skokie resident that in 1977 pushed back when the Nazis wanted to hold their march in Skokie. He passed away a month ago, and just last week, the New York Times learned about it. When the band of Nazis proposed to exercise their right to free speech by staging a rally in 77, he was incensed, a survivor of 9 concentration camps. He did not understand why acolytes of Hitler could demonstrate in the United States, let alone in his predominantly Jewish community of Skokie, where, of course, many Holocaust survivors had moved after the war. The idea of a Nazi gathering in Skokie, a suburb of Chicago, was like being put back in the concentration camp, he told a local TV station at the time. He became an activist inspired in part by his disagreement with Lawrence Montrose, his beloved rabbi at Skokie Central Congregation. During Rabbi Montrose's Yom Kippur sermon in 1977, Mr. Stern recalled, the rabbi told his congregants to close the shutters, close the light, and let them march if the rally occurred. I jumped up and said, no, Rabbi, we will not stay home and close the windows. We will not let them march, not here, not now, not in America. We will be in the street and face it. I heard an uproar in the congregation that the people agreed with me. He passed away, like I said, a month ago in Berkeley. He was disappointed that the ACLU said, we're going to take this case. I heard that cost the Illinois ACLU half of their membership because they fought. The ACLU, though, they responded with, let me find that quote here real quick. They responded by saying, if they hadn't fought this, if the First Amendment permitted stopping the Nazi march, it would have allowed white citizens' councils in Mississippi to stop civil rights demonstrations. Although Skokie lost the legal fight, the village was spared the Nazi rally. Instead, they demonstrated in Chicago. In Chicago, an estimated 5,000 demonstrators turned out against the rally. Some chanted, Death, death, death to the Nazis. The demonstration, which was held outside the federal building, included 29 Nazis and lasted 10 minutes, said the LA Times. Is that all there is, Mr. Stern asked when the rally concluded. But that's the kind of hate that we've seen far too much of recently. I wouldn't want the government to impose limits on hate speech because I tend to agree with the ACLU leader. As long as they're not direct threats, the kind of threats that will get you in trouble. If you name the people or the small group that you intend to harm, unfortunately, hate speech is permitted. Many of my students have argued very persuasively that that shouldn't be the case. That's probably one of our enduring disagreements, and that is, what can the government do? But if somebody were to tell me Facebook and YouTube and X and all the social media companies, they can't censor that if they want, or they can't moderate that, I'd say, no, I disagree with you completely. They're private, profit-making companies. And if they want to make a profit, then they need advertisers. Elon Musk is learning this part. He's never had to advertise Teslas. Teslas sell by word of mouth. He's not very familiar with advertising. He doesn't have to advertise SpaceX because it doesn't sell to the public. But it turns out you need advertising to make online social media function. And a lot of companies said, we're out. And then a New York Times event last year, he yelled an obscenity at the advertisers who were there, telling Disney, don't advertise with me? Blank you, he said to the CEO of Disney, Iger. He needs to realize that advertisers don't want their stuff anywhere near Nazis or racists or any of that content. That's why they moderate that content, not because they have to. Well, President Biden has been accused of coercing social media companies. That's another case that's going to be in front of the Supreme Court. That's where the Biden administration called up the social media companies routinely and said, take down that false content that ivermectin is a cure for COVID-19, or that hydroxychloroquine is a cure for COVID-19. Take down that content that some quack posted that said, if you take some colloidal silver and some zinc whatever, that'll cure your COVID-19. And the social media companies, as far as I can tell, they didn't complain. They routinely engage with government leaders. And in fact, to their credit, both two of the Supreme Court justices, Kavanaugh and one of the women, I believe it was Elena Kagan, they were both White House lawyers. And they said at the oral argument, yeah, this is routine. This happens all the time. White House and the administration and federal agencies, they call the media all the time and say, that was false. Here's the correct facts. And some of the more conservative justices like Alito said, I'm concerned. This is coercion. And I'll agree, if the government orders social media companies to take content off, that's a violation of the First Amendment, right? But if social media companies get a friendly call and they say, hey, that Levick posted some crazy nonsense, take Levick's postings down, I wouldn't think that's a problem if I were posting dangerous things like masks make you sicker if you have COVID-19, so you want to make sure nobody wears a mask, back in the days when we were all told, thou shalt wear masks. And so if I were to post that content, as long as the government doesn't threaten them, as long as they just persuade, I think that's okay. We'll see what the majority has to say. Many of these cases I've mentioned, the observers who write in the media, the mainstream media, have said, court seems skeptical. The justices seem skeptical of the Texas and Florida laws. They seem skeptical of those who are complaining that the Biden administration coerced and twisted the arms of the social media companies. And then there's one more I want to mention, and that's a unanimous decision. This is the unanimous decision written by none other than, let's see if I can find it here. That's not the one. It's a unanimous decision that came down. Here it is, Justice Amy Coney Barrett. A city manager, when he was in college, opened a Facebook account. And he posted lots of pictures, and when he got married, he posted pictures of his kids and posted various things, but he also became the city manager of Port Huron, Michigan. And so he had more than 5,000 friends on Facebook, and you can't have a private account if you have 5,000 or more friends. It has to be public. So people throughout the pandemic started to complain about the pandemic restrictions, and he would point them to the proper source. Well, a gadfly in his town filed a lawsuit that said, this guy, he deleted my posts and then he blocked me from his social media account. And the Supreme Court took the case and said, they're going to send it back to the lower courts because different courts of appeal around the country had different rules. And so they sent it back to the courts so that they could elaborate on the correct rule. And this, I think, is the one really optimistic decision, because the Supreme Court completely unanimously said, yes, if a government person runs their personal account as a government account, then they shouldn't be deleting things or banning people. And I think it was Amy Coney Barrett wrote, all they have to do is have a private account, Levick's family picture account, and then Levick government official account. Our former president, he posted things on the official President of the United States account, on his real Donald J. Trump account, and on his Trump campaign account. And he treated all of them as official. A lot of people sued him when he blocked them and he deleted their posts. And the Court of Appeals ruled that he had to let people back on because those were government accounts. He treated all of his accounts as government accounts. And then after he lost the election, the Supreme Court ordered the Court of Appeals to vacate their ruling because it was no longer needed. It was moot once the president wasn't president. I wish they hadn't done that. They should have decided that case because now they wouldn't have to decide this one. But that's my optimistic decision of the day. The rest I'm not so excited about. This was the Supreme Court looking at the law and not looking at politics. I thought that was the best decision of any of them that I read. I've